Hello, everyone. Welcome back to the Passionately Wrong podcast. My name is Randy Searles, and I'm here with my good friend, James Bellerjo. And today we're going to talk about contracts in everyday life. What are they? Do we need them? Do they need to be signed in written form? I was talking to James about an episode of Black Mirror which is on a series on Netflix. And basically this lady, her life was taken and made into a TV show. Like the day she was doing it, the next day her life came out on this TV show played by Selma Hayek was playing her, for instance. And she thought it was a violation of her rights. But when she signed the contract online for Netflix, it wasn't Netflix, it's called Strawberry Streaming, but it was the equivalent of Netflix. She basically said, yeah, you can take anything I do in my life and put it in any of your shows, no problem. But she just fine print. So we thought we'd do especially since I got a lawyer here, James, we talk about contracts and whether I guess I'll talk about another thing I discussed with James was I do contracts on my editing. So people hire me to edit their manuscripts or to do coaching. And I don't actually have a contract that they sign. I've never felt like I needed it. I tell them what I expect from them and what they expect from me, and they agree to it in an email, and then we move on. And then I've been told by a lot of my peers that you should do it that way. What if you have to go to court? You don't have anything viable. And James assured me I was okay, but we'll let him discuss that.
Okay, so thanks for that opening, Randy, and for the couple questions you asked. I think the questions you're asking center around the formalities of contract formation. If I click and accept the terms of an online streaming service, is that somehow legally binding me? And if I have an oral exchange with a potential client or an email exchange with that potential client, and we discuss the terms of our relationship, I never signed anything, they never signed anything. Have I nonetheless created legal obligations for me and for them? And the answer is, in short, we are all entering into contracts all the time without thinking about it or realizing it, because there are no special formalities that you need to observe. You don't need to have a signed piece of paper in a closing ceremony to legally bind yourself to someone or to the terms of an agreement you have with that person. All you need is a very narrow set of circumstances which are easy to satisfy. Someone has to make you an offer. You have to accept it. You both have to have given something of value, and you intend to be legally bound. There's an additional one, which is that you have the capacity to be bound. So a minor can't enter into a legally binding agreement in the same way that an adult can. You can't do it if you're, so that one doesn't come up as often, but it is actually an interesting question. When your children are signing up to services by themselves, is that a legally binding agreement in the same way as when you do? Maybe, maybe not. But, there was a reason why kids weren't allowed to take Ubers by themselves for quite a while. But anyway, let's deal with the first part of it, offer, acceptance, and consideration. So when you say to a client, whether it's in a phone call or an email, or you have, let's take the more common situation. You don't actually have a contact with a client at all. You've got a website which says, I'm Randy Searles, book editor. Here's the services I offer. Guess what? Your web page is an offer when you say, I offer these and these services, depending on how much you describe it and what detail it is. Same thing with an airline website, a streaming website, everyone who's offering you services that you can look up on the internet and they describe their services and the terms of their services, that is an offer. So they're making a contractual offer to you. Hey, I'll provide you these services under these conditions. We'll talk about yours in a moment about how detailed they are. Then a person comes along, I'm looking on the internet, I want to book a flight, and I see United offers a flight to Zurich for such and such a price. I never talk to them. I just look on their website. I click on the button that says, yeah, I'd like to take that flight. That button that a person clicks or the email that they send determines in large part whether or not a contract will be formed. Because for a contract to be formed, there has to be acceptance of exactly the terms that you propose. So if you put out on your website, hey, I'll offer book editing services for $200 an hour, let me know if you'd like to take me up on it. A person writes back to you and says, Randy, I want to take you up on your services. And they just say yes. Or maybe the better example would be, I just click buy this flight from United. And that's all I do. If you accept exactly what the person proposes, that's it. You've got the conditions for a contract to have been formed. And it doesn't need any more than that. It doesn't need a signing, like I said. It just means you have an offer and you have an acceptance. Now, you don't have acceptance. You don't have a contract that's formed if the person doesn't accept exactly what you offer. So if the person, instead of saying, yes, Randy, I want your services, or yes, I want a flight, they instead make a counter proposal, they ask a question, they do anything but simple acceptance, then you don't have a contract yet. So if they say, hey, is there another flight that gets me there 2 hours earlier? Or do you have any space available in premium economy? So they haven't just said yes, they've asked a question or countered. Or they say, hey, Randy, I can't afford to pay full price for the book, but if you give me 10 hours for free, or whatever, they make some counter offer. Then they've made an offer, which you have a chance to accept. So if you want to think about it, contract requires simply somebody offered something and the other person accepted it. If there's any variation, the offer wasn't clear, all the terms weren't defined, or the person didn't simply accept, then you aren't yet at a contract. So the question of exactly when a contract formed is determined by the outline of an offer and an acceptance, but that's all it requires. The offer can be made in any form. The acceptance can be made in any form. How are you, the email exchange or me clicking something online with United seems pretty clear that it's possible for there to be an offer and an acceptance. I think what people underestimate sometimes is that every time they click, I accept or I know or, okay on an app or on the internet, they are actually quite clearly doing something that result in a legally binding contract. Your clicking of that little button that says I accept is the moment at which a contract is formed. And that's the reason they do it that way. There's no negotiation, right? You're not giving a counter offer when you click Apple's terms and conditions and say, yes, fine, fine, fine. You click through those things as fast as you can without reading them. That's a contract. So let me stop there and say, does what I just described make sense to you? Does that make you feel better or worse about the ways in which contracts are formed? Any specific scenarios that you'd like to get more detail on?
No, and that's, without knowing the law, for lack of a better word, that's kind of how I rolled. I just said, hey, I told you what I wanted and you agreed to do it. That seems like whatever a contract we would have signed would have done the same thing. So I figured I was on even Steven water with that. And I appreciated that you agreed with me.
Now there is a benefit depending upon, how significant the amounts involved are to having a contract that is more explicit. And that is, let's say I'm selling you something worth $100,000. I don't want there to be any misunderstanding about exactly what I'm selling you, exactly when you're going to pay me, exactly how we're going to transfer title. So it helps to write that out and say, okay, for the avoidance of doubt, Randy, here's exactly what we're agreeing. When the stakes aren't as high, you don't need to be as formal, but that's, the process of creating an agreement is in part, or of writing an agreement, part to ensure that we both have exactly the same understanding. Hey, you said you did my book, but really, what did that mean? Does that mean you're going to write it for me? That you're going to make it a bestseller? That, they may have a very different understanding of the services that you're going to offer. So the more you can be sure that you really do have the same understanding as your client. By the way, that's the real secret in a good contracting. When you're dealing with people on a one-on-one basis, it's not how cleverly you write the contract and how many ways you put in there to protect yourself. That's what people think lawyers do. I think what lawyers do when they draft good contracts is really just make sure that you and your counterpart actually understand the same thing. Your client's not going to be surprised when,
Clarity.
Yeah, exactly. When you both understand that you have the same goal in mind, or you understand exactly what services are being delivered, there's much less opportunity for someone to come back later and say, oh, I thought you were going to deliver me a car, not a bicycle. I said means of transport, but that's not what I understood. And it's ambiguity, the lack of clarity that creates contract disputes most often.
I understand. And I'm very clear, like what I expect from him and what he should expect from me. I'm super clear about that. And I got that, the price and everything. What I have had to deal with, I've had to deal with NDAs, what are the non-disclosure agreements,
Yes.
a couple times where people think that their book idea is going to be, someone would want to steal that idea and make it their own. And to tell you the truth, for people who don't know, the book industry, once you get a book published I mean, if it does well at all, it's probably already been copied and has a different title and a different cover, and someone else is already promoting it or something. Unfortunately, because in this world, digital files just get taken really fast. And then if you find it, you can always get it taken off of Amazon and stuff like that. Sometimes though, it gets reversed. That guy puts it up and he gets you taken off Amazon. Kind of weird. Anyway, but I've had some people come to me as an editor and say, "Hey, I want you to sign this NDA so that you don't talk about what's in my book, so that you can't steal my idea." And I never have a problem with that. I don't know how binding an NDA is, and I guess it depends on what's in it because it's just a contract, right? But I've signed a couple mainly because I don't know if most of these people understand, but no one wants an unfinished idea. No one. If you're not writing books, if you don't consider yourself an author, taking an idea and not having one to write it is worthless. So most people aren't going to do that. But what do you think about NDAs? Is it a more powerful contract?
So NDAs are a particularly annoying type of contract. They are contracts just like anything else. They suffer from two flaws that I think would make it worth people's while to consider using them or not using them, and also be careful signing them. And here's why, really. It creates a significant proof issue. So let's say you signed an NDA not to make any use of your client's book about a wizard who goes to magic school and has a scar on his head, whatever. And then, J.K. Rowling comes out with a book about Harry Potter. And then the person whom you signed that contract with says, "Hey, Randy, you must have told J.K. Rowling about my book because look, she came out with this great story." And you say, "No, I never talked to her." And they say, "Oh, yes, you did." And first of all, the burden of proof is on them. So that's good for you. If they want to prove that you breached the contract, they have to prove you breached the contract. That issue right there is immensely difficult because there are very few circumstances where it can be easily proven that a person has breached an NDA. Sometimes you can, but that's the first issue you should think about, which is how likely am I going to be able to determine whether someone has breached the agreement or not? And that should help you figure out whether you want to ask people to sign the NDAs or not, and whether you feel comfortable signing an NDA. One of the reasons I think people do sign NDAs is simply not because they ever think they're going to be able to enforce it, but because they wish to agree with you. Hey, it's important to me. Yeah, it's important to me. Be careful with it. I'd be happy I really would like you to keep it confidential until we know what happens to this. That's a good goal. And so the signaling function, maybe there's other ways to do it, but getting someone to sign an NDA and actually sign it physically and send it back, that helps reinforce for you to take it seriously. Yes, I want to keep it confidential. Then I think though, what happens where people go wrong is they say, well, I do have a proof issue and I do want to make sure Randy takes it seriously. So what you see, at least in Europe a lot, less so in the US, but watch out for it, is people put in what's called a liquidated damages clause, which says, and oh, by the way, if Randy ever does violate this and let slip that I'm writing a book about a wizard named Harry, then he'll pay me $50,000. That gets to a separate issue, which is how do you prove what the damages are? So the person may have had a stupid story idea about a blob named Larry. Well, that blob named Larry wasn't worth much, but somehow you let it slip in a conversation. Oh, you've got this dumb client, and they can prove that you let it slip. Have they been harmed or not? In most cases, the answer is, well, no, you're never going to be able to prove damages. There's no easy way to show what your inadvertent disclosure caused by way of harm to that person. So the way people get around that is they say, well, if Randy ever slips up and I can prove it, issue 1, issue 2, did you slip up? Can I prove it? But let's say they can prove those two things. We're going to agree in the contract that the damages are going to be $50,000 per slip up. You see that clause all the time, and it's a stupid clause and a dangerous clause. I want to say it's not a stupid clause because it's the contract. If you agreed to it, they can come later and say, "Hey, sorry, Randy, I know you were just talking to your friend at the bar, but now you owe me $50,000. So if you do sign an NDA, I would look to make sure it doesn't have a liquidated damages clause. These are usually short 1-pagers, 2-pagers. Make sure they're not telling you that you're going to pay a fixed dollar or a fixed amount if you violate the agreement. And if it doesn't have that, or if you can get that clause taken out, then fine. I'd say little harm in signing the NDA. Little benefit, but the one case I know it makes sense is if you have an idea that you're planning to patent or protect under some intellectual property law, and then that's one of the ways you prove that you took care to keep the idea secret so that you can, if it's been disclosed before you file for a patent, then you can't file for the patent. It has to be still secret. So an NDA in those circumstances makes sense and is necessary. In almost every other setting, it serves a signaling function. And so, okay, fine, little harm as long as it doesn't have a liquidated damages clause.
Okay. Is something more binding than another? Like if I just do a handshake deal as opposed to an email deal, as opposed to on the phone, we agreed to it. Is it just harder to prove, or are they less binding in general?
It's a question of proof, and they're equally binding. So it is the reason people get to formal written agreements is they really don't want to get into a question arguing later of, well, we agreed to this on the phone, and so you say, no, we didn't agree to that on the phone. I asked you a question and I, counter offered. Proof is the main reason why we do written contracts, because you don't want to get into a discussion about what exactly was the term of the offer, what exactly was the form of acceptance. Did it actually happen? By the way, you can prove an oral contract, and people prove them all the time. It's just then you go through longer steps at the beginning when you wouldn't have had to have done it if you had had a written agreement. But the way to form a contract is exactly the same. Offer, acceptance, we both agreed to something. And that can be done orally. It can be done by a handshake. And the benefit of a contract is simply you don't have the hard time proving it. So think about it in terms of copyright. You wrote a book and you publish the book. If you register your copyright, that doesn't improve your copyright. It just means that if later you need to prove, hey, I had published that book already on August 12th, 2020, and I can prove it because I have my book on file at the Library of Congress, whatever. It's just a question of proof. It's not a question of whether your rights are any stronger or less strong. And the distinction I would draw is, ask yourself how important the matter is to you. So when people click on their phone, accept through all of those click buttons, when they download a new app or a new streaming service, whatever, they're making implicitly the decision, well, whatever these terms are, they're not important to me, because unlike the Black Mirror show, I'm not going to have, some studio actually taking actions that affect me later. I would question that only because people are giving up a great deal of private information and all of their online activity when they accept those terms. They're very one-sided. I've read those terms. I've written those terms. And I can tell you, it's limited to what you're doing online and stuff like that. Usually they don't go as far as the TV show you described, but nonetheless, you're giving up a lot of information that you probably place a low value on, but they place a pretty high value on. Now, you could also say, go ahead.
So if you ever had to go to court over at least like Netflix things that you're going accept, and there's something just crazy that no one would expect to be in there, but you missed it because you accepted everything, or and to tell you the truth, some of this stuff is in such small print and there's so much, I don't even understand what I'm giving up sometimes, but I want to watch my Netflix show. If you actually went to a court case and they brought all their highfalutin lawyers there and you brought, Joe Schmo lawyer to help you, do you have a case that a judge could throw the whole thing out and say, no, that's ridiculous? Who would think that they signed that? Because this is ridiculous. Is that something that could actually happen or hasn't happened?
It can happen. There are defenses to contract formation that say we didn't really have a meeting of the minds because although I clicked the button that says I have read and understood, we can show that in practice, nobody actually reads and understands those terms. And therefore, you'd have to make an argument. And I don't know, it is possible to argue that a contract wasn't formed for reasons like the ones you're describing, either because nobody actually reads it. So you can't say I technically accepted those terms, or because even though most of the time the stuff that you ask for is what a person would reasonably expect, you agree to abide by the terms of service, you're not going to post inflammatory content, et cetera. If the company adds a term that says, oh, by the way, you have to give us your firstborn child for indoctrination. Actually, we do that, don't we? But if they say explicitly something like you have to hand over your bank accounts on the first of every month, then a judge would very likely say, hey, there was no meeting of the minds on that term. No reasonable person would have ever clicked yes if they understood that term was in there. And then I think you would have a good argument, Randy, that no contract was formed. But you don't want to be in that position of having to defend against contract formation. And the point is simply not to say you should read the terms of every agreement you're entering into, more just to start with the understanding that you are entering into a legally binding agreement each time you click, I accept, I understand, I acknowledge. Those are legally contracts just the same way that if you were to sit down at a closing with a fancy lawyer and sign the agreement. And you're making a risk call and a judgment call each time you say yes. Now, turn it around, Randy, and say, hey, James, well, how do you behave? Does it affect how you sign agreements? And I would say, first of all, yes, I'm a little bit schizophrenic. I will read every word of an agreement that someone puts in front of me to actually sign, to physically sign. So when I go to do a rope climbing course and the organizer puts a liability waiver in front of me, I'll read it, even though it basically just says they have no responsibility if you kill yourself using their facility. But, I'll still read it to make sure there's nothing in there that shouldn't be in there. Same thing with a car lease agreement, same thing with a rental property agreement. Now, I don't do it with the online agreements. I have read Apple's online terms and conditions and Microsoft's just for classes I teach. And, reading them, I will say they are among the most one-sided agreements ever. But at the same time, I can't say that I feel like the risk is high that Microsoft is going to come after me or Apple's going to come after me. Really, what they're trying to do is make sure that if anything bad ever happens as a result of something I do, they won't have any liability and I can't sue them. And so that seems like an okay trade-off to me. It's not a big risk to me. Yes, I don't have any protection in my relationship with them, but they're not really interested in coming after me either. This is the thing that I think makes the system still work. Big companies don't actually have an interest in coming after you and me, little guys. They just don't. There's no upside to them. So people probably correctly conclude the risk is small.
So I used to be the security manager in Colombia for the embassy, for the military people in the embassy down in Colombia. And we had, it started out like this long and then it ended up being 2 pages of rules, basically because people were doing dumb stuff. So we had to add it to the list, like, hey, don't do this. And then someone did something else or was a little bit different than what we put in there. Like, all right, don't do this, this, and this. And, one of the things that there was a period of time where people would, go on trips down to South America and almost every incident that caused harm to someone or embarrassment to the United States involved alcohol. So the solution to the general that was in charge of all the troops there's a general of Southern Command that's in charge of all military people in South America from the U.S. military. And he decided hey, if you go down to South America, you're not allowed to drink because I think that's going to solve all the problems. But if it doesn't solve the problem and you cause an incident after you're drinking, you're going to get double slammed because whatever you did that caused the problem is going to get slammed. Plus you disobeyed a direct order. So it was kind of elevated everything, And so I would read the problem was if you were permanently assigned there, like I was, you were allowed to drink because you lived there and you every day for 365 days for 4 or 5 years, you lived there. And therefore you were allowed to drink because you were allowed to live your life. It was all these temporary duty, the TDY guys that would come down for 2 weeks and go nuts and cause problems. And most of the issues were caused by the TDYers, to tell you the truth. Not all of them, but most of them. And so I had to read the riot act every time they came in. And so I had this list and I would sit people down and say, all right, I'm going to go down this list. You're not allowed to drink. Any questions? And, all this stuff. So we had this one incident where these guys went and drank and they brought their guns to the bar for some reason. And they said they felt threatened, but because we got the video footage, they didn't look very threatened. They looked threatening. And it was kind of you ever see Taxi Driver, James?
Mm-hmm.
Yeah. He's like, you talking to me? You talking to me? Are you talking to me? Well, there was no sound, but that's what it looked like on the thing. Like they walked by some guys that were sitting at a table and maybe there was a slur, like, yeah, stupid, whatever. And you talking to me? And then he pulled the gun out and shot into the roof of the bar. And it was a very entertaining video footage. It looked like Benny Hill in the end where people were running around the car. And then 2 years later, I get called in to federal court and they fly me to San Antonio to go to the court martial for these guys. And they're like, okay, what were the rules? Like no drinking. He's like, yeah, but is that really a rule? I was like, yeah, it's a rule. It's like, does everyone follow it? It's like, everyone that's TDY has to follow it. It was like, well, why don't the PC? I mean, this is a military judge. So he's in the military and he just doesn't know the scenario. And I had to explain all this stuff. And he's like, I don't know. I mean, is that really a rule? I mean, how can you tell people, grown men, not to drink? And I was like, I mean, sir, you're a colonel. He's a general. He told them not to drink. I don't know. I don't understand the question. But anyway, they ended up doing time served and went on with their lives. But it was, to me, that would have been a contract. They signed it. I put a little thing on the bottom. They signed. I didn't know I was making a contract, but I basically made a contract. But it wasn't a contract court. No one was saying they made a contract and said they wouldn't drink. And ultimately, when I finished the court case, and that has nothing to do with our podcast, but I was like, I'm not even sure while we're discussing whether they could drink or not. I'm pretty sure it's conduct unbecoming an officer in an NCO to drink and shoot guns in a bar while you're on a military operation. That sounds reasonable to me. That why are we even talking about this? But and the military's got something that's a catch-all. If they just don't think you should do it, it's just conduct unbecoming. They're like,
Right.
That's not the way a sergeant should act. Conduct unbecoming. Next.
So what you're getting at, there's two things in that I want to highlight, and that is people doing dumb stuff is the result or is the reason for lots of rules. That is absolutely true. Every warning label that you've ever laughed at on a product, you can guarantee is the result of some person doing exactly that. Don't clean your lawnmower blade when the lawnmower is on. Every single thing you can think of is actually somebody did it. And now because somebody did it, the lawyer in that company says, well, we got to let people know, we got to put them on notice not to do this so that if some other dumb person does it, we can say, hey, look, we told you. That's not so much a question of contract formation as how tort laws work. Is a person going to be responsible for a risk or an accident? And, who should bear the responsibility? And a big part of what you see in contracts is actually just disclosure. Hey, Randy, I'm putting you on notice. Disclaimer, 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 disclaimer. And basically, you were trying to get an agreement from your soldiers who came on temporary duty to say, I agree, I won't do these behaviors. But at a minimum, by getting them to initial or sign that piece of paper where you said you're not allowed to drink, you were putting them on notice of that being an issue. So the second piece is coming back to the proof question. So we talked before about, can I prove that a contract was formed or not? If someone has done something bad in the course of a relationship, you have usually many different ways to try and pursue them. So if I think someone has performed a criminal act, can I prove that they did the actual criminal act, or can I prove something related to it that isn't the same, but is close enough that gets me, I can get them on some charge. So if you look at the charges against President Trump right now, he's probably most at risk from his obstruction of justice charge, that he simply refused to give stuff back and prevented the agents from getting documents back. Not so much that he had something that was so horrible. Maybe he did, I don't know. But, there's different ways you can come at somebody, and the language of your contract will have a role to play in determining how easy it is the other side can prove you breached or violated the contract. So I would say this, especially when you're signing a written agreement, that means somebody thought it was important enough that they needed to get a record of it. And that record serves to benefit both of you, but it also serves as the reasons for which you might be held later to have found to have violated the contract. So it's worth your time to just read it. Just read it. I used to get business people coming into my office all the time with a contract and say, hey, is this okay to sign? And my first question to them would always be, did you read it? And that's because you don't have to be a lawyer to read a contract. And there might be some gobbledygook in there, but oftentimes there's a bunch of stuff that really is simple and easy to understand. So for example, we would get customers asking for, service of their machine within 8 hours. And it's in Kazakhstan somewhere where we don't have an office. And I asked the business guy, well, can we service that machine? Well, yeah, sure. How would we do it? Well, we fly a guy in there and, you take him 3 days to get there. I was like, this says we have to have the machine up and running within 8 hours. How can we do that? Oh, we can never do that. Well, okay, we can't sign that then. You've got to go back and negotiate. So simply reading what you're being asked to sign, I think, is a good, healthy practice. You're not probably asked to sign in paper many contracts. And the times that you are, I would say it's worth spending a few minutes to just read the thing. And by the way, if you don't understand a clause, just ask. Say, hey, what's this in here for? What does this mean? People, you may be at the front line of the car rental counter or the airline counter and you're afraid of annoying people, but I think it's a small matter. And I would get into the habit of reading the contracts before you sign.
That's fair. All right.
So,
I think that's a really good point. I mean, if someone puts a contract in front of you, I mean, maybe not all these, maybe you do need to read all these Zoom and Netflix stuff too. But if someone takes the effort to make a contract and stick it in front of you and put a pen in your hand, you should probably read it.
You've given me an idea for maybe a short series of articles, Randy, where we take the 5 or 10 most popular online contracts that people sign, whether it's Netflix or iPhone or, Microsoft's terms, Facebook. Just have a lawyer read them carefully and say, oh, hey, dear consuming public, did you know that in the Facebook terms and conditions, you're agreeing to these 3 outrageous things? And that wouldn't change anyone's behavior to click accept, but it might change Facebook's behavior at not putting themselves one-sided and terrible terms in their agreements. I'm not saying that they're in there. I'm just saying that would be an exercise that might be worthwhile. Maybe I can get my contract students to do it for me and that build up a little reference resource over time. That's tricky though, because of course those online terms, one of the reasons people put terms online is so that they can change them quickly and that you don't have to go out and enter into a new contract with everybody. Your terms are still binding based on the day you signed it. But if you didn't print them out, how are you going to prove that what your terms were at that given point in time? Anyway, I don't know if we've given people useful advice today or not, Randy. I guess if it's to be tied back to passionately wrong, it would be to remember that whenever you're accepting, you can accept and enter into a contract orally, via handshake, via email, via click, not just via writing. So that's just a simple point. Those are all contracts and all legally binding agreements. And that if the circumstances are important to you and or the other side thinks they're important, such that they're putting a formal contract in front of you, take a few minutes to read it. That's probably the minimum advice that I would want to leave people with.
And then make sure you have like 10 hours when you sign your mortgage, because that thing's locked.
The other, the mortgage is a good example, and your contract with the online places. I know we probably wanted to wrap up, but I'll just say it. Sometimes there is no negotiation, right? Your mortgage agreement is going to say what it says, because by God, if they lend you money, they're going to get that money back. And you need to understand that gives them all of the rights and all of the power. And you might say, hey, it's not worth trying to negotiate with Apple or the bank because I know I have no rights in this circumstance. Still worth reading. Probably doesn't take you 10 hours. Maybe you can get the contracts sent to you in advance. But sometimes you simply have no negotiation ability and you just say, all right, I do want to enter into an agreement with you. I want the money. I want to buy the house. And I recognize I have no real negotiation power in this circumstance. That's probably, if I think about it, the practical reason people never bother reading agreements that they click online. They're not going to negotiate with Netflix. Their only choice is use Netflix or not. And hey, I really want to watch this series, so whatever. That's a fair point. Fair.
Well, I think he cleared some stuff up. I mean, till I spoke with you, I didn't understand if I was doing something that was going to bite me in the butt later on. And I actually talked to a lawyer who was an editor. It's like, no, you need a contract. And I was like, what's the contract going to do that I'm not already doing? And I'm glad I talked to you about it, because that's just an extra step in my business model that I didn't have to do. I mean, I was right, more or less. We'll see.
Here's a last bit of advice I would give to people who are running a business. And that would be, regardless of your form of contract, pay attention to the flow of money. If you get the money in advance or partially in advance, then that resolves pretty much all your problems. Because when would you ever sue a client, Randy? You wouldn't, first of all, and second of all, it would be because they didn't pay you. So if you get that person to pay you 50% upfront, well, okay, at least you've got your some of your time covered. And when are they ever going to sue you? The answer is also never. The only issue is ever going to be about payment. And for most things, that's where I think the disputes are going to arise. I was either happy with the services or I wasn't. But the way that it plays out is I pay you or I don't. So if you set up your business such that you have a fair and reasonable, you don't ask for 100% of the money up front, but you say, hey, I'm going to provide you coaching services and to compensate me for the time and effort I put into getting up to speed. You agree to pay me 50% up front. Some kind of fair compromise so that you're not taking all the risk in the relationship. Never mind the contract. It's just how should the money flow go? I see you contemplating there. I don't want to ask you how you do it, but that's one thing that I would say you should consider is when people pay you and how much they pay you. Of course, you want happy clients. You want them to come back and say, yeah, Randy, of course, I was delighted, only too happy to pay you. But yeah, the timing of payment is one of the ways you can reduce your risk greatly in any kind of relationship.
Okay. Well, I think we got some good tips out there. I think this works.
Super.
All right, everyone. We'll see you next time. Thanks for stopping by. Make sure you subscribe and like. And if you guys got any topics you want to cover, leave them in the comments.
Thanks, everyone.
We'd love to hear what you think. So please comment on the show with your thoughts. We read all of your comments.
Thanks for joining us, and thanks for subscribing. See you next time.